the difference between a trademark and a copyright? What do they each protect, and how can you know whether you need either of them? Let's talk about it. Hey friends, welcome back to my YouTube channel. I'm Faith Mitton, an attorney on a mission to simplify brand protection for business owners. On this channel, you'll find lots of practical, easy to understand insight about trademarks to help you better understand how to protect yourself and how to stay compliant with the law. Today, let's clear up some confusion about trademarks versus copyrights because they tend to get muddied in people's heads and we need to disentangle them. They are very similar, but they are also very, very different. Starting with the similarities, trademarks and copyrights are both types of intellectual property that you can register with a federal government agency for nationwide protection. In the case of trademarks, the relevant agency is the U.S. Patent and Trademark Office. In the case of copyrights, the relevant agency is the U.S. Copyright Office. But aside from the fact that different agencies are responsible for issuing registrations for copyrights versus trademarks, there are other important differences that you need to know. Let's start by defining what a trademark is versus what a copyright is. A trademark provides legal protection for a business's brand identity. Trademarks are also known as source identifiers or brand identifiers. They communicate to people which person or company is the source of a particular product or service. Things that are commonly used as trademarks include things like names, taglines, and logos, but the trademark universe is pretty huge. And this kind of protection can also extend to non-traditional things like colors and scents and building designs and hashtags and domain names and sounds, as long as those things are functioning as source identifiers. Trademarks are crucial for businesses because they help to build brand recognition and customer loyalty. On the other hand, a copyright does not identify a brand. Instead, they identify a person's creative work, such as a book or a blog post or graphic design, fashion design, choreography, art, sculpture, photograph, online course. The copyright universe is also huge. Copyright protection gives the creator the exclusive right to use, distribute, make money off of, and otherwise exploit their work, although in some cases that right can actually extend to their employer or someone else to whom the creator transfers those rights. So how do you get a trademark or a copyright? The good thing is that there is a free option for both. The bad thing is that this free option doesn't really get you that far. Starting with trademarks, you get certain trademark rights automatically simply by using a brand identifier such as a name, tagline, or logo in public. These are called common law rights, and they don't require any legal fees or filings. They simply come into existence the minute that you begin using your trademark publicly. Common law trademarks are identified with two symbols: the TM symbol, which stands for trademark, which applies to products, and the SM symbol, which stands for service mark, which applies to services. Now let's get to the limitations, because common law trademarks only give you protection in the places where you have actually made sales. And that's it. If you want broad protection that extends to the entire country, then you will need to apply for a federal trademark registration. Federal trademarks are identified with the circle R symbol. As I mentioned before, the USPTO is the agency that is responsible for reviewing trademark applications and issuing trademark registrations if the application is approved. The application process is not simple or quick, however, and it will take you at least 12 months, and probably longer than that, to get your trademark approved, if it is ultimately approved and not rejected. So if you are interested in a federal trademark application, the best time to apply is always as soon as possible, even today. There's also a free common law version for copyrights. Common law copyrights are automatically created, just like common law trademarks are automatically created. However, common law copyrights come into existence when the creative work is put in some sort of tangible format. So that means things like writing your book on a piece of paper or on your computer, or snapping a photograph, or recording a video. No legal filing is required for a common law copyright, and they are not geographically restricted the way that common law trademarks are restricted. A common law copyright will give you protection in the entire country. However, if someone does copy your work, there isn't much you're going to be able to do on the basis of a common law copyright alone. You will need a copyright registration. These registrations are issued by the U.S. Copyright Office, like I mentioned at the beginning, and they are a requirement in order to file a copyright infringement lawsuit. And they are also very, very highly recommended if you are trying to get infringing content removed from the internet without filing a lawsuit through the DMCA or Digital Millennium Copyright Act. Getting this kind of content removed without a lawsuit is known as a DMCA takedown. And although common law rights do exist, these internet platforms are not going to play ball with you without an actual registration, because otherwise they're playing a game of he said, she said. They don't have time for that. They want to make decisions based on actual legal rights that they can certify, and a copyright registration helps them to do that much more quickly than relying on a common law copyright. The copyright application process is a bit quicker than the trademark application process, but it will still usually take you a few months to get a registration. So again, it's always good to apply before you need it. But both common law copyrights and federally registered copyrights are identified with the circle C symbol. Now you may be wondering, do these trademark and copyright protections exist forever? Good question. The answer is not exactly. Trademark registrations, which I love, which we talk about on this channel all the time, can last indefinitely as long as they are properly used, they are properly maintained, and defended against infringement. Copyrights, on the other hand, have a definite expiration date. In most cases, a copyright will last for the lifetime of the creator plus an additional 70 years, though there can be minor variations to that. But after the copyright expires, the creative work enters the public domain and anyone can use it without permission. So how is trademark infringement different from copyright infringement? The idea being you want to protect your intellectual property from being misused by someone else, and you need to know how to identify when infringement has occurred. The main difference is that trademark infringement does not require intention, whereas copyright infringement does. In trademark cases, it's enough to show that someone is using a trademark similar to yours in a way that could confuse people, regardless of whether their motive was to steal your clients and customers or whether they were even aware that your business existed. On the other hand, copyright infringement usually requires some proof that the infringer copied your work without your permission. That means that for copyright infringement, you will usually have to show that the infringer had access to your work and then took it and used it without your permission. So the distinction between trademark infringement and copyright infringement is going to affect what type of protection you seek and what kind of evidence you need to gather in order to protect your rights. All right, let's do a quick recap. Trademarks are about protecting branding and identifying a particular company or person as a source of certain products and services. They can last indefinitely with proper use, renewal, and defense against infringement. Copyrights protect creative works like music, art, books, sculptures, choreography, writings, etc. They usually last for the copyright creator's life plus 70 years, although that can differ in certain situations. But both trademarks and copyrights are essential for protecting intellectual property and ensuring that you reap the benefits of your hard work. And there you have it, trademarks versus copyrights. If you found this video helpful, I hope you will like it. Be sure to subscribe for more trademark content and hit the notification bell so you don't miss when I drop a new video. If you've got questions or thoughts to share with me, please drop them in the comments. I'll be happy to read and reply. Thanks for watching. I'll see you in the next video.